have joined us. Mark Durkin has joined us, Stephen Dunn and Anya Murphy. Hold on, bear with me 1 minute. Okay, we're still waiting on the officials coming in, so members, if you just take your ease for a couple of moments. Come off. Well, can we come off again for a minute or two, Antoinette, until they come in?
Seems to be an issue with Starleaf at the minute, if you just want to...
All right, we'll just hang fire. Okay, members, we're still live, just to remind us.
I've muted the room.
Oh, have you? Oh, good, okay. Didn't know you could do that, Antoinette. Good for you.
Cool.
Yeah,
Still be careful, though.
Yeah.
you know, we're starting at, agenda item 3.
Yeah.
That's fine.
There's Kieran's in.
We're just really going to run right through from start to finish again, Chair, from 1. So we'll not be getting to that 14 and 15 for a wee while, so we'll try and clear the earlies, because that's going to take quite a bit of time. If we can get through the rest. For sub-clauses where there's less, maybe on them. If we can get another wee bit of time with Claire at the end, it would be
Yeah,
useful.
well, we do the date time next meeting before we're going to close session then, if we, at the end, rather than
yeah,
wait
probably,
minute.
yeah.
Kieran's here? Yep, she has that now.
All right, we're ready to go. All right, folks, we're going to then move on to agenda item 3, which is committee deliberations on the betting, gaming, lotteries and amusements amendment bill. Members, before we begin this session, I want to ask if you're content that we send the delegated powers memorandum for the bill to the examiner statutory rules for comment. Content? Yeah. Okay. Members, just to inform the committee will now continue its deliberations on the betting bill. This is the only item for discussion at today's meeting. Members, this is not yet the formal clause by clause stage. We're still continuing to go through the clauses and comprehensively review with the department any issues raised by stakeholders or committee members, and to ask for clarification on how the bill addresses these concerns and any additional action that the department intends to take on the back of the evidence the committee has received. Members, you've been provided with a copy, or provided with papers for this item starting at page 19 with a copy of the bill. The evidence summary table start at page 267. The departmental responses to queries raised at the meeting on the 13th of January is now in your table papers issued yesterday. Claire McCanny from the Bill Office is following, as always, proceedings and will be available to the committee for a closed session at the end should members wish to discuss options for potential committee amendments. Are members in agreement to proceed? Agreed? Good. Members, just to remind members that the question or comment should be focused on the specific clause under discussion, and if our members are content, then we'll make a start and welcome departmental officials. So can I welcome then Kieran May and Martina Campbell You're both very welcome today. Good to see you.
Thank you.
Members, then we'll go through each clause again as a reminder to what we discussed at last week's meeting. So clause 1, interpretation, there are no queries have been raised by the committee on that. So we'll move to clause 2, which is opening of licensed offices on Sunday and Good Friday. Members, last week we queried why Easter Sunday was not a day the offices were closed and what type of events would be taking place on Easter Sunday of benefit to the licensed offices. We also requested some examples of events that take place on Easter Sunday when it would be of benefit to licensed offices to open. The committee also queried the future potential of a gambling regulator for Northern Ireland and also a gambling strategy, and why there was at least no enabling clause in the bill for a regulator. The officials stated last week that such powers are better in secondary legislation and that also more research was needed on that. We asked the officials to confirm these explanations and the Minister's thinking on these matters and also any further information regarding to the potential appointment of an independent advisor to take forward the work needed. So Martina and Kieran, might be useful if you could run through some of those points and the responses. Can you hear me?
Yes, can you hear me okay, Chair?
Can indeed, yes.
Okay, great. So do you just want me to go through our response then to you on that?
Yes, please.
Okay, sorry. I was panicking, I wasn't on there. Right, so the policy intention is to primarily remove the prohibition on bookmakers opening on Sundays to bring them into line with their counterparts who are permitted to operate on Sundays. That's the on-course dog tracks and licensed amusement arcades, and also to ensure fairness for land-based operators against online operators who can operate 24 hours per day. We're not aware of any policy reason why bookmakers shouldn't be permitted to trade on Sundays, given that other retail and leisure outlets are permitted to open. As regards examples of what happens on Easter Sunday, some sporting events which take place either have or are about to. The World Snooker Championships, European club football matches, some GAA matches, small motor race meetings, such as Brands Hatch, horse racing, rugby and American basketball. And just sort of to remind that some people bet on sporting events and fixtures which take place all over the world and not just local to us. So that's our response on that, Chair.
Okay, thank you. Martina, members, any comments or further queries the one around this part? I know, Paul, you had raised that last week around some of those issues around Sunday or Easter Sunday, but nothing further at this stage. Or?
Is this the clause 2 with
Clause
regards
2.
to the bingo halls on the Sunday too?
Yes, that's in a further clause.
Clause 6.
I'll leave it to there then.
No, we'll leave it at that then. Anybody, any further comment on clause 2, or can we move on? All right, then we'll move on then to clause 3, which is Sunday working in licensed office. We queried if the Department for the Economy will have to make any changes to its law due to proposed Sunday working. Officials stated that it was their understanding that this bill and the 1985 order are in line with current employment legislation, and I think we had the same issues when we were looking at the licensing bill around that as well. We've asked the officials to confirm that understanding in the response. Again, for the record, can you just run through that response, Martina?
Surely. We confirm there's no need for DFE to make or amend any of their legislation. Our Minister obtained the agreement of the then DFE Minister to amend our Schedule 8A in the 85 order, which confers the same rights as those which exist already for workers at racecourses, dog tracks or amusement arcades. Clause 3 amends Schedule 8A of the 85 order, which states clearly at paragraph 1.5, this schedule shall be construed as one with the Employment Rights Northern Ireland Order 1996. referred to in the schedule as the Employment Rights Order. So I should just say that workers' rights are contained within a range of employment legislation, but mainly within that particular order, the Employment Rights Order. So we're satisfied that the protections by virtue of the amendment to Schedule 8A and Clause 3 is sufficient to cover workers' rights for Sundays.
Okay,
Thanks,
you.
Chair.
Thanks, Martina. Members, any questions or further comments anybody wants to make on clause 3? No? Okay, then we'll move on to clause 4, which is pool betting.
Sorry, can I just
sorry, go ahead, Paul.
to go back to clause 3, just to place on record my concerns with the belief from the Institute of Public Health and the Public Health Agency, where Public Health Agency says that the extended opening hours may exacerbate existing harms, and also the Institute of Public Health won't support Sunday opening without there being a gambling strategy and a regulator in place. So it's just to put that on record, Chair.
All right, okay, thanks for that, Paul. Any other comments members wish to make? No? Okay. All right, then we'll move on to clause 4, which is pool betting. No queries were raised by the committee requiring a response from the department beyond what was discussed last Thursday. I'm going to ask if members any further comments on that today, on clause 4, pool betting. Nope, no further comment on that. I'll move on then to clause 5. Persons who may participate in bingo at bingo clubs. Again, no queries were raised by the committee requiring response from the department beyond that which was discussed last Thursday. So again, members, any further comments today on clause 5? No, okay. Then we're going to move on to clause 6. Days when bingo and use of gaming machines permitted in bingo club premises. Last week, the committee queried the rationale for this clause, and officials highlighted that it is intended to allow bingo to take place on Sundays and Good Fridays, and amend the anomaly so that gaming machines in bingo clubs are made available on those days, as arcades can open already on those days. Our discussions last Thursday widened into illegal gaming machines found in taxi depots, takeaways, etc. And the officials were asked to confirm in response that the bill is not dealing with these illegal machines. There are also committee queries around a register of purchasers of gaming machines, and officials advised us that work was ongoing to locate information from the court service. Members queried if the bill should have a clause which would lead to improved collection of data. Officials stated that DFC is having conversations with its statisticians to see what would be possible in the future, and the Minister has written to HMRC to see if access can be given to gambling, duties paid, etc., to inform the next stage reforms. Officials were asked to provide the information from the court service as soon as it is available, and to confirm in writing the range of data gathering the department is hoping to be able to do to inform the second stage of reforms. So again, Martina, for the record, could you run through those key points in your response on those issues?
Sorry, Chair, there's a lot of interference on the line. Do you want me just to do about the data collection, or both the bingo and the takeaways and the data collection?
Kieran, could I ask, Kieran, can you mute yourself? I don't know if you're on mute or not. It's just there's a wee bit of background. Oh, it's okay. Antoinette's told me she's now muted you, so she has. Sorry, to see if that is the issue. We don't know. No, if you could just go, it's just for the record to run through all of those key points and and responses on the issues. Martina.
Okay. So, sorry for the bingo opening hours. The policy intention is to remove the prohibition, to bring them into line with other gambling operators who are permitted to operate on Sundays, to ensure fairness for land-based operators against online operators who can operate 24 hours a day. We're not aware of any policy reason why bingo halls shouldn't be permitted to trade on Sundays, given that other retail and leisure outlets are permitted to open. Opening on Easter Sunday is in line with what happens with other jurisdictions. We were advised by the industry, by some operators who have bingo halls in Britain that Sunday is their busiest bingo night. The facility to play bingo online already exists, as I said, and operated during lockdown when commercial bingo halls were closed. As regards gaming machines and taxi depots, obviously only the courts can give a definitive interpretation of the law, but our understanding of the law is that gaming machines are not permitted in fast food restaurants or taxi depots in any circumstances. And Article 95 of the order has a general restriction on the use of gaming machines, which has an offence attached to it. And then we also refer committee to Articles 95, 105, 107, 108 and 122, which specify that amusement with prizes machines can only be used in amusement arcades and similar premises which have been granted an amusement permit, commercial bingo clubs licensed by the courts, licensed bookmaking offices, the bar areas of public houses and licensed hotels, registered clubs and travel and showmen's pleasure fairs. Article 81 of the 85 order prohibits anyone from supplying a gaming machine unless they hold a gaming machine certificate, or in the case of a single transaction, a gaming machine permit. Article 129 allows a landlord to evict a tenant or occupier of any premises who is convicted of allowing the premises to be used for the purposes of gaming. So overall, we consider that there are sufficient powers within the 1985 order to allow for enforcement action to be taken against such premises as taxi depots and fast food restaurants. On the data collection from the court and general data collection, we have, as the Chair, you've said, have been having ongoing discussions with Professional Services Unit about how and when and what type of data we could gather, and about establishing some baselines going forward. A prevalence study was scheduled for 2021 but was postponed owing to COVID, as no face-to-face surveys are currently being undertaken by NISRA. Separately, Professional Services Unit are having discussions with their colleagues in Department of Health, as there's limited information about the numbers of people presenting to services reporting gambling as a primary cause of their addiction or poor mental health. Discussions are also taking place with colleagues in the South and in the Gambling Commission in Britain, with a view to piggybacking on any surveys or research being undertaken in those jurisdictions. Professional Services Unit are exploring the options for having a set of questions included within surveys, such as the Young Person's Behaviour and Attitude Survey aimed at 11 to 16-year-olds, and also the Continuous Household Survey. As stated above, these surveys are currently suspended owing to COVID because they're face-to-face, and surveyors are not allowed into the schools at the minute. So Article 177 of the 85 order, that should actually read, allows us to request returns from the courts about the number of licences or permits issued, the number revoked as a result of conviction or an offence, and other information as required. This information is currently being collated, and the returns were due back last Friday, but they haven't all come in. So as soon as we get a copy of all of the returns, we'll let the committee have that information. So far, it's not really yielding any information about the number of gaming machines, which is an option that the courts can do. They can specify the number of gaming machines per licence. Minister recently wrote to the Treasury Minister seeking a copy of any useful data that HMRC might hold, for example, the amount of gaming duties paid by operators here, or the number of machines from which gaming duty is collected. A response was also received on Friday past the 14th, and HMRC claim that such data is not available below UK level, and that in any event it has no powers to allow us to have access to that information. Research and statistics will form an integral strand of the proposed Phase 2 reforms, but other departments, in particular Department of Health, who are responsible for treatment of gambling harm, will need to also invest in research, particularly around treatment models. And if Department of Health does decide that they want to adopt a public health approach, then obviously they would need to invest in evidence-based public information campaigns. And finally, further discussions will also need to take place with HMRC to see if we can get some data sharing agreements and what exactly they hold. That's it, Chair.
Okay, thanks Martina. Okay, members, clause 6 then. Did you want to, Paul?
Yeah, on the data collection piece, because I think this is very important going forward to inform any sort of strategy that we would have. We have a enabling clause for a code of conduct or code of practice. We have an enabling clause for industrial levy. Should we have an enabling clause to give you guys power to collect data of third parties?
Well, we have Article 177, which allows us to require information from the courts. So at the minute, I think that is probably sufficient. The court service has agreed that they'll have discussions with us once we collate this information and see whether or not there's anything more that they could do to help us give us data that which on Thursday we talked about being able to interrogate the data properly and extract more useful information. So I think given the framework that we have, the legislative framework that we have at the minute, we probably have sufficient powers without specifying that. Obviously in Phase 2, when you would be developing a new regulatory framework and if the decision was made to go for a regulator, that the regulator would receive more information in from the licensees. So like the Gambling Commission they receive a lot of financial data, they receive the tax data and all of that. So that's why they can produce all of these reports about gross gambling yield, number of players, the amount of money that's being spent, etc. But at this stage, I don't think that would be useful in the bill, because we wouldn't have that capacity to do that right now.
Okay. Thank you. Thank you, Chair.
All right.
Okay, thanks, Chair.
Anything further on clause 6, folks?
Just,
Go ahead, Mark.
Chair, one wee point, if you just bear with me, Martina. I think, Martina, you'd says that there was sufficient power, or that the existing legislation order was sufficient to allow action to be taken regarding illegal machines or machines unlawfully in premises that they shouldn't be. Do we, or does the department have any information or any idea as to how frequently those powers have been used or are used?
No, we don't. I'm sorry, we don't. We can contact the PSNI and ask, but we don't have that information to hand, but we'll certainly look and see if we can get any info for you on that.
No, that would be useful, Martina, because that would then help determine the adequacy of the existing powers in that regard. You know, here we are again, we're dealing with gambling legislation, and I don't know, is there any intention to look at this also, this aspect of it in the next mandate, but then we have to deal with illegal gambling as well as legal.
Yeah, I think one of the the issues is that, you know, I suppose the police have to, I mean, obviously I can't speak for them, but they probably have to prioritise, and a lot of the fast food outlets with gaming machines, I mean, it's an offence for anyone to supply that premises. So, so you have an offence there for the fast food owner. You have an offence for whoever supplied that machine, and then you have the offence that they're not licensed. So, I mean, I think there is sufficient powers there. It's up to the police, obviously, to enforce them, and that would be a decision for them whether or not they're choosing to use those powers.
Yeah, or you know, there might be an issue around their awareness of them as well. Okay, thank you.
Yeah.
All right, thanks, Mark. Anybody have anything further they want to query or ask around clause 6? Nope. Okay, then I'll move on to clause 7. Offence of inviting, etc., persons under 18 to play gaming machines. Members, last week we queried how a grab machine could have money wrapped around a prize as under 18s play these machines in shopping malls, etc. Officials confirmed that this was illegal and they were working on a voluntary basis to eradicate that. Officials were asked to confirm what work has been done in that regard. Members also queried why there was no notices on the front of gaming machines regarding the law on maximum prizes and legal age to play the machines. Officials were asked to confirm if this is something that could be done in this bill or through more detail being provided in the Code of Practice. So again, Martina, can you go through and responses on those queries?
Surely. So again, it's for the courts to provide a definitive interpretation of the law, but grab machines with prizes in excess of £8 should not be accessible to children under 18. There are different kinds of grab machines, and I probably should have made that clear last week, where the machine is based on skill. It's not covered within the gambling legislation. So those grab machines which are based on chance rather than skill would fall within the 85 order and be amusement with prizes lower type machines. So the maximum stake for an amusement with prize lower limit machine is 30 pence per play, and the maximum value prize is £8. So there are three options for payment of that prize. It can be £8 in cash, it can be a non-monetary prize such as a teddy bar, or tokens exchangeable for a non-monetary prize up to the value of £8, or a combination of a cash prize and a non-monetary prize, or finally tokens exchangeable for such a combination up to the value of £8. Another type of grab machine is the one in which the maximum prize can be up to 25. The prize must be paid directly from the machine in cash, and the maximum stake per game is 30 pence. So there are no restrictions in the 85 orders specifically on the use of gaming machines by children. There are, however, restrictions on the access of under 18s to certain premises in which gaming machines may be available for use. So under 18s must not be admitted to licensed bookmaking offices. This prohibition doesn't apply, obviously, if the young person has reached the upper limit of school age leaving and is apprenticed to the bookmaker. And they can't be allowed in, under 18s can't be allowed into amusement arcades or similar premises holding an amusement permit, which they can't be admitted to those premises or parts of those premises in which £25 prize machines are available. So the purpose of this clause 7 is to introduce a new offence of inviting, causing or permitting a person under 18 to play anything other than a lower limit gaming machine, i.e. those machines with a maximum prize value of £8. So that's it, Chair.
So then, Martina, there could be a grab machine that gives a prize of £20 note or whatever wrapped around something, but that is for over 18s only to play.
Yes. Yes, and there could be a grab machine which has a £20 note, but it isn't covered under the legislation because it relies on skill, and so they're excluded. It's only where games of chance are classed as gambling, so that would be only covered in the gambling legislation.
Do you see that there'd be any way around that where there were a company or whatever could argue that this is based on skill and not chance? Because I think they're all chance, in my opinion, but not that I know if they're
If
played
I
one.
win, it's based on skill.
Yeah. Well,
Kind
sorry,
of,
Chair.
you can see that where some, you might be told, well, actually, this is a skill to actually do this, when we all know it's not.
Well,
what is a skill? What is skill for any machine? What is it?
Have you any information on how many crane drivers wins these prizes?
No. I think you would need to examine the mechanism, and that's how you would establish what type of machine it is. But I think most of the skill type machines are older machines. So certainly it would be the intention in phase 2 to better regulate all of those machines and bring them under the legislation. But at this stage it wasn't possible to put in the legislation definitions of gaming machines, or to expand the definitions of gaming machines, unfortunately.
Right, I've got myself now totally confused on this. So can I just ask, so if it is a gaming machine that is based solely on skill and it has a higher prize, but it's skill, are under 18s allowed to play that?
Yes, because if it's based solely on skill, it's not covered by the 1985 order. But if it's based on chance, and most of the machines now have software within them where it is a random number generator, and so therefore it is a game of chance, and those are covered. So those machines which are with the higher prize on up to £25, they're not allowed to be played by under 18s.
Okay, all right, I think I've got that clear now. Members,
Sorry.
okay, it's not you, Martina, it's me. Anybody, anything that further they want to ask around that clause, Mark?
Games that are a combination of both. You get some games that's like a quiz game, but then there's a chance element to it as well. Sorry.
Yeah, if there's any element of chance, it's covered. If it's purely skill, and again, I think you'd need to examine the mechanism within the machine to be sure of that. But generally speaking, if it's relies on skill, it's not covered under gambling legislation. If there's any element of chance, it's caught within the legislation. So it's either an under £8 machine, which under 18s are allowed to play, or it's an amusement with prizes lower, £25 maximum prize machine, which under 18s are not allowed to play.
Clear, Mark?
Yeah.
Okay.
Clear as mud.
Martina, Kelly had brought up the issue last week about notices being placed on the front of machines rather than in the vicinity.
Yes, sorry.
Anything further on that?
Yes, sorry, I thought I must have covered that.
Okay.
So there's no requirements to display such notices on machines. There are, however, requirements for notices to be displayed both outside and inside premises where high stakes gaming machines are located. When a council is granting an amusement permit, it considers conditions, including whether or not there's physical barriers in place in the premises where machines for over 18s are located as well, and they also require a notice to be displayed at the entrance and inside. So I had included in the response an extract from the article, so I'll not read that unless you want me to, Chair, but basically the council can delay issuing the permit until the premises, they're satisfied that premises have sufficient physical barriers in place. So the Code of Practice on page 12, as currently drafted, has this requirement for a notice to be displayed inside the machine, inside the premises, and as well as outside. If the committee wish, we can certainly amend the Code of Practice to require a notice to be displayed on the machine itself, or where it is not physically possible to include such a notice on the base of the machine, for example, because of the design in the machine that it would cover the monitor or something like that. We can require that it is there's a notice displayed close to the machine where it would be visible. Overall, we believe that new Article 124A inserted by Clause 7, i.e. the offence of inviting, causing or permitting an under 18 to play a high-stake game machine, will strengthen the existing protections. Thank you, Chair.
Okay, thank you for that. I do know that in certain establishments, licensed establishments, let's say, whether that's a private members club like the bowling club or whatever, there will be a sign on all of their machines because they have a mixed, children will be in there, and they generally do. And if you'll see the signage on them. This over 18s only. So I think there are a lot of people a lot of those businesses are quite responsible anyway when it comes to signage. So they are. Sorry, Paul, you wanted to come in?
Yeah, just on clause 7. So it's been brought to my attention that there is a grave difference between our legislation and GB as regards gaming machines. How does this bill, well, first of all, are we established that GB have got it right? And if they have, and I believe this has dogged the Assembly for a good number of years. So I suppose my question is, how does this fix the gaming machines issue, and probably within that the fixed term betting machines terminals issue? How do we address?
Okay, so not entirely sure what all you're getting at there, but
I'm not sure myself.
If I understand what you're asking about the difference between how we treat fixed odds betting machines, and that would be the stakes and prizes on that, I think is what you're getting at, the £2 and £500 limits. So currently within the legislation, we treat fixed odds betting terminals as high stakes gaming machines. So the current maximum stake is 30 pence and £100. Kieran will correct me
Hold on,
if I'm wrong.
Hold on, Kieran's trying to come in. Antoinette, if you can let him in. Go ahead, Kieran. Hi, we can hear you now.
Yeah, right. I hope I'm not causing any more interference. I think it's 30 pence and 50 pence are the two maximum stakes, and is it 100? It's not. It's £100. Yeah.
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 I think it's £100.
Yeah.
Okay. Thanks,
Double
Kieran.
check it off the top of my head.
Yeah. So at the minute, the stakes and prizes here are the lowest anywhere on these islands. So in 2019, when England changed the legislation to make the maximum stake per play on fixed odds betting terminals, when they changed that to £2 max, the bookmakers here voluntarily agreed, those bookmakers who are members of the Turf Guardians Association voluntarily agreed to reduce their machines to the same, so that they were obviously trying to be responsible. We had hoped that we could have inserted a much clearer definition in the bill around fixed odds betting terminals. However, colleagues in the Office of Legislative Counsel cautioned against that, and generally about transporting definitions from the 2005, the British 2005 Act into our order. And the main reason for that is because our order is so old, it deals with betting, gaming separately, as opposed to treating everything as gambling. So it had been Minister's intention to include, to be very clear on fixed odds betting terminals, but it wasn't possible at this stage, and that will be dealt with in phase 2. So stakes and prizes generally here are legal stakes and prizes here are generally much lower than in any other jurisdiction. So in terms of fixing issues, I think what you're referring to, Paul, is probably the whole issue around fixed odds betting terminals, that these people can lose extortionate amounts of money in them. And we believe that generally they are, that issue has largely been resolved. And in fact, whenever the England issued DCMS, the Department of Digital Culture, Media and Sport, issued their call for evidence on the review of the Gambling Act, they got over 16,000 responses, and they have advised us that there were no substantive concerns raised within any of those 16,000 about fixed odds betting terminals. And I should also say that fixed odds betting terminals are generally only available in bookmakers' offices here. They're not generally available elsewhere. So I hope that answers your question, maybe?
That was very informative and thorough, thank you. And is it the same then for what I would call bog standing gaming machines? Is there differences there?
I think the only difference there would be on the stakes and prizes, and the other difference actually would be on definitions. So England has, I think it's about 8 or 9 different definitions of gaming machines, but by and large, they all have the same limit. I don't have my stakes and prizes limits to hand at the minute, but I'll send it through after this. So as you can see, what's the limits in England, Scotland, Wales, and what's the limit in the south of Ireland. In fact, the south only changed their limits last year, and their limit is the same. It's €5 maximum stake and a €500 prize, and then the lower machine is, I think, 30 cents and €7, but I'll send those tables through to you after that.
Yeah. So can I ask then, whilst you've been advised, because of the age of our legislation and the difference between gaming and betting, that it was to be in the face of the bill, is there then something you can do in the Code of Conduct that will shore up that assurance?
Yes, so we have done that within the Code of Practice. We have covered fixed odds betting terminals. The 1985 order, as it currently sits, permits 2 machines, maximum of 2 machines in bookmakers. So it specifies that, I think it's 108, Article 108, I think, of the order. So that we have taken that and inserted that in the Code of Practice. And if you think, I mean, we'll come on to talk about the Code of Practice, but the Code of Practice is, I can't emphasise it enough, it's in draft form. And we're happy to take on some more, you know, to see if we can do any more within the Code of Practice that we can't obviously do in legislation at this time.
Okay, thank you.
All right.
All right, thank you.
Thanks, Martina. Anybody else, anything further then on clause 6, or sorry, clause 7? Clause 7? All right, then we'll move then on to clause 8, which is arrangements not requiring persons to pay to participate. The discussion on this clause last Thursday centred on the two key issues of promotional prize draws and prize competitions, and members wished it to be clear in the bill that companies can include Northern Ireland residents in such draws and competitions, and that it is not illegal. Officials highlighted that clause 8 is setting out removing the requirement to pay, but the further thinking may be required around these matters. Officials were asked to update the committee on what further actions wording could be included in the bill to respond to the concerns raised by the committee. Martina, over to you again.
Okay, so I appreciate that this is very confusing, and I think I got myself in a bit of a muddle last week talking about it, but I'll try not to this week. So, as the law stands at present, the conduct of any prize competition in which success does not depend to a substantial degree on the exercise of skill is prohibited. So under Part 4 of the 85 Order, any competition arrangement is deemed to be a lottery if participants are required to pay to participate. So promotional prize draws, which require the purchase of a product, e.g. a chocolate bar or a newspaper, or the use of a service, such as taking out a bank or building society account, to qualify for entry into a prize draw or competition, could technically be construed as a form of payment to participate. So therefore it would constitute an illegal lottery. This is because these draws don't fall within any of the permitted lottery categories set out in Part 4 of the 85 Order. Clauses 8 and 11 make express provision for circumstances in which arrangements should not be deemed as payment to participate, and Schedule 15A of the bill sets out those circumstances in more detail. Clause 8 amends Article 131, which is about illegality of lotteries, to make it clear that free draws are to be excluded from this clause, and the proposed new Schedule 15A sets out what is or isn't considered payment to enter. So for ease of reading, we had reproduced below how Article 131 should read, assuming Clause 8's approved. So I'll not read that out, Chair, unless you want me, but basically it's making it clear that an arrangement isn't a lottery unless persons are required to pay to participate. So prize competitions in which success does not depend to a substantial degree on the exercise of skill are prohibited under Article 168. And then for ease of reading, we reproduced what Article 168 might look like if Clause 11 went through. And again, I'll not read that out, but basically what it's saying is that any other competition, nothing with respect to the conduct of competitions where there's, an arrangement is not a competition for the purposes of this article unless persons are required to participate, and draws the reader's attention then to Schedule 15A. So when you look at 15A, it reads, I think, quite straightforward. And we believe on balance that further clarification or amendment of the clauses isn't needed. As regards given any kind.
Nope, you're frozen on us, Martina.
Because.
Sorry, you're okay. You just
Oh,
froze there for
sorry.
a moment. You froze there for a moment, but you're back.
Sorry, yes, my internet seems to have been flickering on and off today, so apologies. So on balance, we think that further clarification isn't needed because clause 15 is pretty straightforward and sets out what is and isn't payment. And ultimately, it's for the companies involved to make the decision whether or not to change their position on allowing residents here to enter such draws. So hopefully you got all that.
No, it did indeed. I can see Paul Fraser chomping at the bit here to come in. So
I imagine he is.
So again, you're much more learned than me, Martina. But I'm still struggling with 8 and 11 combined, and then with Schedule 15A. And whilst you say it's clear, I still can't see where that tells me that my bank can offer me a prize draw by the fact that I am just a member or a participant in that bank account. So my direct question to you guys is this: whilst I can understand you wouldn't want to change the face of the bill because it, as you say, it lays it out clearly, I don't see that clearness. So I suppose what I'm asking is, can you exemplify this stuff on the explanatory and financial memorandum to make it at least clear? So, because I can see something happening here. We talked earlier, Mark talked about the enforcement of these laws. And about the police issue with regards to gaming machines. This isn't like that. But you can still foresee that Northern Ireland's 2% of the population of the UK. Those big banks and building societies, they aren't going to change their ways just because the Assembly changes their laws. It's going to take a customer going to them and challenge them on this and saying, well, look, you should offer me this because the law has changed. And to me, that's the way this will change. So, in order to help the customer base and the population of Northern Ireland, if they can point to a line that states that that bank or building society has nothing to fear and they're not breaking the law in Northern Ireland, then I think that's what I want to see. It also helps me go back to my constituents and say there it is, because I can't at the minute do that with 8 and 11 and 15A. So I suppose that what my ask is that if you can't change the bill, and I can understand why you wouldn't want to tamper and mess about at this stage with regards to this specific ask, whenever you say that it's clear. But the white paper of the EFM, to me, is the way to do it then.
Yeah, I mean, I'm sorry that I haven't
No, it's not your fault, it's my fault.
I think maybe when we come to Schedule 15A, it might help, but basically what you're talking about, the Banker Building Society type draw is a promotional prize draw. So if by the fact that you have to have, I think it's £10,000 in Halifax to be able to be entered into the draw, means that technically speaking, you have purchased a product. So there is no free entry route available for other citizens in Northern Ireland. So therefore, that makes that illegal. Now, what clause 8 and 11 is doing is saying that you don't have to purchase, as long as the entry is free, you don't, it's not illegal. Yeah. So therefore, if you're buying the product, the chocolate bar or the washing machine, as Kieran talked about last week, you're buying that anyway, and then as a bonus, you're being or incentive, I suppose, to buy that machine. You're being entered into a free draw, but it's free. You're not paying any more than the purchase of the product. So then, you know, that means it's not a payment
Yeah.
to enter.
And I suppose where I'm struggling is 8 and 9 basically clears the way. It doesn't explicitly say that this can now take place. It just means it just says it can clear. It just basically clears the way. And I suppose
yes, it removes impediments.
yes,
we think.
So yes, it does, and I agree with that. But then I suppose what I would like to see on the EFM is an example. So and we have this in occasions in the past whereby you're able to cite in the explanatory notes an example of what clause 8 and 11 would do.
Yeah.
I'm not saying it needs to be in both, but it's just and use the example of the bank account or building society account.
Yeah, surely we'll certainly look at that, and if it's possible to put it in the EFM, we will put it in the EFM. That's not a problem. So we'll explore that with OLC and come back to you on that.
Okay, thank you very much. And
okay,
we spent a lot of time on this, but it isn't.
I know. I'm sorry.
It is important. Thank you.
There's Kieran trying to come in. If you can unmute him. Go ahead, Kieran.
No, I was just saying we're going to try and talk through Schedule 15A if we can today, and hopefully that might help make it a bit clearer as well.
Yeah. And can I just say,
but it's complicated.
And not to put undue pressure on, but you do realise and you do know that we're on a tight time scale here. So when we talk about things that needs to be looked at or changes to be made, we're talking about days.
Yeah. Right. Thank you. Okay. Oh, sorry. Go ahead, Mark.
I'm sorry, and apologies in advance to Kieran and Martina. I know I'd asked a couple of questions around the lottery things last week, and what constitutes a charity or society.
That's our next one. It's
and
clause
the
9.
running of them, is it? Oh, sorry.
Clause 8.
In front of me.
I haven't got to clause
You
9
have been
yet.
more, but there's a bit of crossover, but I'll wait to 9 then.
You want to wait?
I'll wait.
Okay. All right, then we'll move on to clause 9, rules for societies lottery. We recognised last week that this clause needs careful consideration due to the potential impact on organisations that wish to raise money this way. Officials highlighted that the Minister wishes to raise the maximum prize limit from £25,000 by secondary legislation. The committee requested sight of draft regulations as soon as they are available. Members queried if the bill was sufficient in how it dealt with the calculation of prize fund and referred to Article 13714. The committee requested clarification on this issue. Members also queried why the bill is repealing the limit on the ticket price completely, and would a new enhanced limit not be better? Officials stated that the Minister was minded to look at an amendment in this regard. However, the sector is divided on what the limit should be. The committee requested that the department relook at this clause in this regard and consider a new limit. So Martina, then back over to you again if you want to give us a response to that.
Surely. Thanks. So we will provide drafts of the secondary legislation as soon as possible. It's expected, as you've said, that secondary legislation will amend both the maximum price limit and the maximum process. The policy intention behind stipulating limits on spending on prizes and expenses is to maximise the amount of money that can be raised for good causes. And then for ease of reading, we had reproduced Article 137 as it would read when amended. So with your permission, Chair, I'll not read all that unless you want me to. As regards the ticket price limit, having listened to all the evidence and the views expressed, Minister is minded to accept an amendment setting a new ticket price, and we welcome views from the committee on what the limit should be. As you've said, sectors divided. Some clubs and charities run draws where there are smaller prizes every month and a major prize in month 12, such as a car. Such tickets can be paid off in monthly instalments, which doesn't put people under as much pressure to purchase. And this type of draw obviously enables clubs and charities to have a steady source of income and allows them to plan activities based on that. So as stated, Minister is intended to increase the maximum limit as well as the limit on hold proceeds, and hold proceeds is the total value of ticket sales. Is that sufficient, Chair?
Okay, thanks, Martina. I'm going to go to Mark then first.
I'm not so sure that my question's in the right place. I was just going to be around, Martina, are there any trans-frontier issues here? I'm conscious of living in the border constituency, and we do still have a border on the island, but in terms of lotteries, are those run maybe on an island-wide basis by, say, a society or a charity based in the south? Would there be any impediment to them or their lottery being promoted in the north under the current legislation if, say, the ticket price or the prize was exceeded our current limits?
I think the rules for that, and apologies, I should have checked that before today's meeting. I think there would be no issue with anybody here buying the ticket, but there may be an issue with it being promoted here. But I would need to check that for you, Mark, and come back to you on that point. Apologies. I think you did raise something like that last week and I've missed it.
Okay, no, thank you, Martina.
Okay, thanks, Mark. Anybody else, anything on that? Go ahead, Paul.
Yeah, so you've told us, Martina, that the Minister's now minded to install a new price limit on the tickets, that being one, and of course the intention of the bill at the minute is to repeal that line. Now the Minister and Department is considering putting a new one in. You have asked the committee for its views. I suspect the problem the committee will have is that we have not consulted on this, as has been the case for you guys. You guys will have much more information and stock than we will have as a committee, because we're just scrutinising your work, your bill. So that's where I would be concerned. But again, if we are settled that there has to be a new limit, then I think we have to get it right, and I think the committee is here to help. But I suppose I'm wondering, how can we help in such a tight time scale and frame? So if we're minded now to put a new limit, and we're days away from ending our deliberations, and then you're weeks away from going to consideration stage, what do we do in order to change this bill and put a limit that we're confident about, both the committee and the department?
Okay, so the evidence that we have, obviously NICFA made a substantial submission, and from memory their view was they wanted no limit, but right. Minister is of the view there should be some limit. I think, having listened again to all of the evidence. So what we're going to do is we're going to go off today, draft some instructions for Legislative Council, and hopefully get an amendment to you. It'll probably be for Monday, but obviously it depends on what work OLC has on at the minute, because as you know, there's a lot of legislation going through. So we're hoping to get something off to them, and that we'll have an amendment for you to look at for next Tuesday's meeting, hopefully. Certainly we will be doing all we can, and Minister, as I said, obviously will make a decision on that, what the limit should be.
So I'm maybe preempting your work here, and maybe you're not settled on this as yet, and that's okay. But will that amendment include a cost, sum, or will that be an enabling piece of will that be an enabling amendment to allow you to set it at a future date?
We could probably do it either way, but I think our intention was to put a limit in. There is an enabling power within that clause, which allows us to change limits by secondary legislation.
Okay. The existing
So-
137.
Yes, the existing 137 has a clause, I think it might be 21 or 22.
The department may, by order subject to affirmative resolution, substitute for any amount or percentage specified in this article, such as other amount or percentage as may be specified in the order.
Yeah, so we can do it by secondary legislation. We had just done it, I suppose, for convenience, the repealing in the bill. But we are going to be doing secondary legislation anyway. But for this one, because it's in the bill as being repealed, we'll have to put it back in again and put a limit. So it has, that particular one has to be done as an amendment.
Okay, I get that. I'm clear on that one. Thank you.
All right, that's great. Thanks.
Alright, thanks, Martina. Anybody else? Anything further they want to ask around clause 9? Nope. Okay, we'll move on then to clause 10, qualifications by age, residence or corporate status for licences, certificates and permits. No queries were raised by the committee requiring responses from the department beyond what was discussed last Thursday. Can I ask if members have any comments today on that, on clause 10? Nope, no comments. Then we'll move on to clause 11, prize competitions not requiring persons to pay to participate. Members raised concerns that although you may not pay to enter certain competitions, you're providing data that is valuable to organisations. A member reiterated concerns that the bill may still not be clear enough at clauses 8 and 11 on the issues regarding promotional prize draws, etc. Committee is still considering the issues around clause 11 and clause 8. Martina, again, go through any key points on that issue.
Okay, so I'll skip through the stuff that I've already talked about at clause 8. So as the law stands at present, the conduct of any prize competition in which success does not depend a substantial degree in the exercise of skill is prohibited. Clause 8 amends Article 131, which makes it clear that free draws are to be excluded from this clause, and the proposed new Schedule 15A sets out then what is or isn't considered as payment. So we did reproduce the clause 131 as it would be amended, and what else have we got there? We think that this should be a bit clearer, and we don't think any further clarification is needed. But taking on board Paul's earlier point about changing the EFM, I think, Chair, we will look at that and see if what we can do there to try and help provide clarification completely.
Okay, thank you, Martina. Any members, anything they want to raise under clause 11?
No, I'm content with 11. I think there's a discussion to be had at 15A, but I'll hold wished until then.
All right, okay, we're going to then, if no one else wants to ask anything or raise an issue, we'll move on then to clause 12, cheating. Members queried the penalty associated with the offence in this clause. Officials stated that these are on a set scale and there is unlikely any room to alter, but they would be happy to check this. Officials were asked to confirm what the convention is in this regard. Back over to you again, Martina.
Okay, so fines and penalties are based on what is called a standard scale, and this is set out in orders. So the order is the Fines and Penalties Northern Ireland Order 1984. So before setting the penalty attached to any new offence, officials are required to liaise with colleagues in Department of Justice who are responsible for the law on offences and penalties to make sure that the tariff being applied is appropriate and proportionate. And we did this, and DOJ confirmed it was both proportionate and appropriate. So I draw members' attention to a similar offence in the Gambling Act 2005 in England, which carries a level 5 fine and actually carries a prison term of up to 51 weeks or both. Our level 5 is 6 months. So I've reproduced the Gambling Act clause there, but that's and generally, if you look, I think it's Schedule 18 that sets out the offences in the 1985 order. Most of our offences would attract a level 5 fine and 6 months imprisonment or both.
Okay.
So that's it.
Thanks, Martina. Anybody want to ask anything further around clause 12? Nope. All right, then we'll move on to clause 13, enforceability of gambling contracts. No queries were raised by the committee requiring a response beyond that was discussed last Thursday. Members, any further comments today on clause 13? Nope. Okay, then we'll move on to clause 14, industry levy. Members expressed concern regarding the wording of the clause at 172A6 around which groups would be consulted on the levy and whether the industry should be consulted at all. We also expressed concern regarding the National Lottery terminals and scratch cards being such a large part of gambling in Northern Ireland and part of the addiction issues in NI, and queried if the National Lottery would be part of the levy. Officials stated that the lottery is registered for by Westminster and therefore cannot be part of this bill. The committee requested that the department provides improved wording proposals for clause 14. Then over to you again, Minister. I see that Martina. There you go. You're now the Minister. Martina.
Thank you for that promotion.
You're all right. I know it says here the Minister is minded to accept an amendment which expands the requirement to consult as suggested by the committee. Can you take us then through the response, please?
Yes, so as I said last week, it was always our intention that we would consult with other interested parties such as the health sector and relevant voluntary organisation as well. This would be best practice in policy making, that consultation with all stakeholders who represent the interests of those impacted by the policy that they're consulted. So whilst we understand many people argue against the industry being consulted, we believe that they should be allowed to express their views as part of a wider consultation with all other interested parties such as health, the voluntary sector, etc. And we confirm that the Minister is minded to accept an amendment which expands the requirement to consult as suggested by committee, and that would make it clear that the health sector, voluntary sector and other interested parties should be consulted. And as I said earlier, we will try to get that amendment to you for next Tuesday's meeting, if that is at all possible, because it's subject to us drafting the instructions and getting the OLC to do the amendment. On the National Lottery bit, the National Lottery is a reserved matter and we can't legislate around issues such as product placement, location of terminals, or indeed imposing the levy on the lottery. So that's all I've got on that, Chair.
Brilliant, thank you, Martina. Okay, members, anybody want to ask anything further around clause 14, the industry levy, Paul?
Yeah, thank you, Chair. Thank you, Martina. So, again, 14 and I suppose 15 is what we're going to come on to with regards to the code of practice. And I suppose, by way of an example of how concerned we would be at this stage with both these, is the fact that whenever you produced the code of conduct last week, or the code of practice last week, our phones went boogaloo over the weekend.
Yeah.
So you can.
So did ours.
Yeah. So you can see then how these can be very impactful, even though they're at this stage, enabling legislation for the future. So we need to make sure that the blue pages are correct before we can move on. So in saying that, can you go through all the sub-clauses of 14? What it actually does, what impacts it could have, who pays, when do they pay, what will it be used for, and whether the industry levy will be voluntary or mandatory.
Okay. So, certainly happy to go through all of them clause by clause, but what I would say is that this is simply an enabling clause and it is not committing anything as such. All of that detail would be in the secondary legislation.
I agree. I take that, but what you're doing is setting out your parameters, and if your parameters aren't right, then we have a problem.
You're quite right. You are quite right. So, clause 14 then, 172, it inserts a new article into the order. So it allows the department to make regulations in connection with requiring any person who intends to make an application to which this article applies to pay a levy to the department. So this article would apply to the licences which are granted under the 1985 order. So that's a bookmaker's licence, the bingo club licence, gaming machine licence, or an amusement permit. So all of those people would be obliged to pay a levy to the department. So regulations then, which we would make under that power, would set out the amount of the levy, how it's paid, when it's paid, how often it's paid, all of that. So it would, in 3A there, it would make provision for the determination of the amount of the levy according to a specified formula or in some other way. So what that's meaning is that the regulations would specify whether or not we're using, for example, a percentage formula, like a percentage of the gross gambling yield, just for sake of example, or in some other way. So in some other way, that could be that it's per licence, that there's a set amount per licence. So in B, where it's given the department the power to issue a receipt in respect of the payment, and that the court doesn't proceed with the application for the licence unless it's accompanied by the relevant receipt. And C3C is makes provision for the department to repay the levy to any applicant whose application for a licence is refused by the courts or council, whatever. And 3D allows for modifications of the order as necessary to give full effect to the levy. So that would be any changes.
And just on that, needed. Sorry for interrupting you, but just on 3D,
okay.
On 3D then, when you say modifications, is that secondary legislation again?
Yes.
Right, so it's not as if you can just make a modification. It'll have to go through secondary legislation at any given point.
It would be, oh yes. Yeah.
Okay.
So then, 4, the proceeds of the levy are to be expended by the department in providing financial assistance for projects related to addiction to gambling or other forms of harm or exploitation associated with gambling. So what we're saying in that, or what the policy intention there is that, and I want to be very clear here, because a lot of witnesses raised this point that the industry shouldn't be involved in how the money is spent. The industry will not be involved in how the money is spent. The money is paid to the department, and the department will then ask or invite organisations to submit projects. Now, it is quite possible that the intention there is that the projects would be primarily for treatment of gambling related harm, for research or for education. So, for example, public education campaigns or going into schools or whatever and doing courses and things like that. The department then would set out criteria for those projects which would meet those objectives. So the department, when the projects would be received, the department would obviously have an assessment panel and consider which projects should be funded. But in doing that, we are not experts in treatment, so we would have to ask colleagues in Department of Health, or indeed for education projects, we would have to ask colleagues in Department of Education to be involved in that. And it may also be the case that we would decide to, for example, do a technical transfer to Department of Health or Department of Education and give them a set amount of money and tell them, okay, this is for treatment or for education purposes.
I knew you were going to say that. I knew just the way you were carrying on there, that's what you're going to say. So sorry for interrupting you again, but it begs the question, how can we be assured that departments, including this one, will spend this money wisely? And second of all, how can you be sure, as the Department of Communities, that if you hand it over or transfer any money to the Department of Health, that will ever be spent appropriately? Because I'm not sure £1 of the Department of Health's budget is spent appropriately.
Okay, well, I can't comment on that bit, but I can tell you that there would be obviously very strict parameters set around that, and that all of that would be subject to audit and all of that. I'm just saying that is a possibility that we could do that technical transfer, that none of that is set in stone.
Yeah.
And it may well be that, particularly if the department in phase 2, obviously subject to views of executive, incoming minister, all of those caveats, if there was a regulator in place, this would be something that the regulator would handle. So it's, I mean, I suppose what I'm trying to say there is to provide some assurance to organisations that the industry wouldn't have any say in how those proceeds are used.
Yeah.
Is that?
Yeah, no, and I get that, and I get why you would want to reassure that the industry wouldn't be involved, but I'm not sure the department's being involved gives any sort of reassurance either.
Well, who would you suggest then?
That's always the big question. And again, so when you were talking there, I'm thinking, well, if we're going to have a regulator in the future, they might well be best placed to know and find out how this money should get to the ground best. But you know, if we had a fully functioning government with departments that were slick and click and had a programme for government that had public health as a major plank in its programme for government, then there may not be a problem. But we don't have any of that. So that is the issue. I'm not saying it shouldn't be in the bill. I'm not saying a levy shouldn't be, an industry levy shouldn't be there. I'm just trying to work out the mechanisms of this enabling clause. And I'm just, as you're talking, and you've been very thorough in your answering, which is great. It's just, it's raising so many issues along the line.
Yeah.
Which will be for a future date. But what we need to do is make sure that we're enabled appropriately.
Yeah, I mean, you're quite right. The parameters are very important. Well, can I move on then to 5?
Sure.
Or
I
you happy
interrupted you.
enough?
Sorry.
Hold on, Mark, do you want to ask something in relation to that?
It is in relation to that. I know You said nothing is set in stone. Should we look at then what could maybe be set in stone? I don't know if you've looked at other legislation that other departments have brought forward. I'd be thinking maybe of the carrier bag levy legislation. Do you know where it is enshrined in legislation that money generated through that levy is spent on environmental improvement programmes? Might just be worth looking at it. I know we're talking about a different type of levy. As such, the other issue, of course, I would be entirely supportive, and I'm entirely supportive of a levy, but the rationale behind the Sunday opening in this bill, okay, which I'm also in favour of, I have to say, but was to ensure fairness for land-based operators. But this levy, this clause of the bill does the exact opposite, because it's imposing a levy on land-based operators, while those not land-based operators are getting away scot-free.
Yeah.
But it's contradictory, the legislation.
Yes, I can understand why you would say that. If I go back, I'll come back to that. But if I go back to your first point there about the carrier bag levy, you just said, and I haven't looked at the carrier bag levy legislation in a very long time, but I will. The proceeds of the carrier bag levy are to be spent on environmental projects. So what clause, subclause 4 there is doing is exactly the same thing. We're saying that it should be projects related to addiction to gambling, which maybe is a bit of a clumsy wording, might be gambling related harm, might have been better there. So we look at that. Or other forms of harm or exploitation associated with gambling. So I think I personally am happy enough with that clause, that the regulations then would set out in more detail how those projects, you could have in the regulations how the projects would be assessed, how they would be managed, etc. And then coming to your point on this being contradictory and unfair to land-based operators, I see where you're coming from. This power is one of the powers that needs a commencement order to be brought into force. But even before, and we'll come on to that, I think in the next subclause, even before we do any of that, we have a big job to do with Department of Finance, and they in turn with Treasury, in getting permission to introduce the levy to be able to retain the receipts, because a levy is a tax which, as you know, is a reserved matter. So we need to be sure that Treasury/DOF will allow us to keep those proceeds and spend them here. Is that any help?
Yeah, that's where, you know, be it a regulator or a third party to administer the levy aspect of it, I think is certainly advantageous, rather than a department where there is a danger, particularly in times of ever straightening budgets, that it's just subsumed into the department and used for general running costs.
Yeah, before you go on, Martina, could I take you back to 3A? And in the same guise and nature and spirit as I asked you questions about departmental spend, what do you see as being a specified formula?
Yeah, so any regulations that's going to be made under this article will be fully consulted on. So committee heard different suggestions what would be the best model of the levy. So, for example, the the model cited as being best practice most often would be the New Zealand model. So that's where they take the cost of treatment and calculate it and then apply it. There's a formula that they use. So that's what I mean by a specified formula. It could be stated as a percentage of the amount of stakes wagered. It could be the amount of the gross gambling yield, which would be gross gambling yield is the difference between what's wagered and what's paid out in winnings. Or it could be something completely different, like the percentage of treatment centres that are made available, something like that. That would all be consulted on. And
can I ask who would actually have that information on yields? Would that be HMRC? And if it is, do they have a duty to give that to you?
Well, that's what I was saying earlier, that Minister had written, and we got the response on Friday from HMRC. So they have been quite unhelpful, I guess is a way to put it bluntly. So we would have to explore all of that and try and make, try and get some data sharing agreements established with HMRC that we could get some of that data.
And why would HMRC be unhelpful? Is it because that information from bookies with regards to profits and yields and taxation doesn't necessarily have to be in the hands of a Department of Communities?
Exactly. It's tax, and I mean, certainly HMRC do publish statistics, but it is, as I said earlier, on a UK-wide level, and they claim that they don't have it beneath that level, which, you know, my personal opinion is I can't believe that they don't have that by region at the very least, because I'm quite sure that there's targets, etc., and baselines around how much they collect and all of that. I imagine, I don't know, I've never worked in HMRC. Obviously, as Mark says, they're about a regulator being able to collect some of this money and all of that. The Gambling Commission in England, they do get a lot of financial data from the operators, and I think I'm right in saying that they perhaps have some kind of online facility where they can check things, but I'm not certain on that. But they can, they also produce statistical bulletins around gross gambling yield. So obviously in phase 2, that would be one of the things that we would want to look at if it's decided that we do have a regulator here, that all of that information would be available.
Okay.
Have answered all your points. I think I've lost my train.
Yeah, no, I think you were at subsection 5 when I interrupted you, sorry.
Right, okay. I'm glad you're on the ball. Right, so number 5 then, financial assistance may be provided by grants, loans or any form of financial assistance. So that's just a standard clause which gives us a grant making power, basically. And it may be given on terms or conditions which may include repayment with or without interest. And then, as I've mentioned there, it requires the consent of the Department of Finance, and that's because this is a tax, and technically speaking, taxes, sorry, not technically, tax is a reserved matter. So the Department of Finance will have to work with Treasury around allowing us to introduce it, and most importantly, to be able to retain those receipts so that we can then spend the money on health research education. So number 6 then, before making any regulations, the department must consult with organisations as appear to the department to represent the interests of the gambling industry in Northern Ireland. So as I said before, the policy intention there would be that we would have consulted, of course, with health, with other voluntary organisations that represent the impact, represent the interests of people who are impacted by gambling related harm. And we've already said that Minister is minded to amend that, is going to amend that to broaden that out and make it explicit that we will consult with health, with education and any other organisations that represent the interests of those impacted by gambling.
Okay, thank you very much.
All right. Sorry, and then number seven.
Yeah.
Then this is just clarifying that gambling means betting, gaming, or participating in a lottery. As I said earlier, because the order, the 1985 order, is so old, the betting, gaming is dealt with separately. It's not under one general term of gambling, so that's why we've had to put in that explanation there that we talked about the gambling industry and we talked about gambling earlier there, so that's why that's there. And then the regs would be draft affirmative. So that's clause 14, or yes, clause 14. So that's my explanation on that. Is that okay?
You've been through the ringer on 14.
You're all right. That's what I'm here for.
Thank you.
Members, any other
You're welcome.
comments, questions on clause 14, the industry levy at this stage? No, nothing. Okay, just before we move on to clause 15, which I think we might have a bit of debate around that as well, can I just suggest that we take a very quick 5 minutes break and then we'll resume after that, okay? All right.
Sure.
All right.
Thank you.
30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is...
Okay, everybody, welcome back. We're just making comment, Kieran, that you were sitting down there with your cup of tea. So we were. Okay, all welcome back. We're going to then move swiftly on to clause 15. Now, I have a wee bit to read out here, so just bear with me. And just also let Martina and Kieran know that we only have this room until 12:15. So we're against the clock now, so we are. And there is a little bit to read out here. So clause 15, Code of Practice and the schedule. So members, the committee requested that officials go through the Code of Practice and also Schedule 15A to the 1985 order in more detail today. A few queries were raised last week around the Code of Practice, including putting a credit card ban in the bill, and officials stated that it would not be good practice to put such items on the face of the bill, but would be better in the Code of Practice, and highlighted that in England it is a condition of licence to adhere to the code. Members Drumbo Park have written to say the following on the draft code. Much of the draft code is sensible procedural arrangements which we support. However, the provision relating to affordability checks at the proposed threshold is unworkable for licensed tracks and other betting operators. Drumbo highlighted that it will push customers into the black market and online betting that is unregulated and mostly run by companies outside NI, many in tax havens. The provision will also push customers across the border to to licensed tracks in the Republic of Ireland and drive another nail in the coffin of licensed tracks in NI who have experienced and continue to experience incredibly challenging trading conditions during the past 2 years. They take the view that the proposed provision is a fundamental change to betting practice in Northern Ireland that should be subject to detailed scrutiny by the committee based on evidence provided by the industry. Based on that evidence, they respectfully suggest that the committee will conclude that the unworkable provision relating to affordability checks should not be included in the code because it would be considered counterproductive and to do untold damage to the industry. Members, you've also been provided in your table papers with a letter from NIACTA in relation to the draft code. They make the following comments. They also have said that the code is unworkable and also that the 4-week consultation period is inadequate. Compulsory affordability checks on all customers of land-based gambling outlets, or for that matter, any retail, hospitality or leisure outlets do not, they believe, exist anywhere else in the world. They've also said that ATMs are provided in many of their members' premises for the use of debit cards and not credit cards. They've also said gaming machine testing is a technically complicated matter and in GB is primarily restricted to B3 machines, i.e. machines which currently have a maximum stake of £2 and a maximum prize of £500. The vast majority of machines in NI do not fall into this category and are of a type that no longer exist in GB. The draft fails to mention specifically what are the terms of reference of the testing, making any testing impossible. They've also stated a proposed implementation date for the code as being the date of the bill receives royal assent would mean the entire industry would be non-compliant from day one. And then they finish by saying, in the absence of a regulator, even a reasonable code would be difficult to enforce with a level playing field. So can I then ask Martina then any comments and go through the code of practice and also Schedule 15A to the 1985 order in more detail?
Yes, Chair. Do you want to finish Schedule 15A first?
Yeah.
Yeah.
Oh, well, then can I ask Kieran then to take you through 15A?
Yep. Unmute Kieran. Go ahead, Kieran.
Yep. Hello?
Hiya.
Can you hear? Yep, yes.
I can, yes.
Okay. Right. Schedule 15A. I take it you have it now in front of you. Again, Schedule 15A needs to be read in conjunction with clauses 8 and 11. And just to reiterate what Martina said earlier, the problem at the moment is that under the 1985 order, where a person has to buy a product or service to qualify for entry into a non-skill prize competition, it isn't generally considered a free draw on the grounds that there's a payment involved, albeit it's for a product or whatever. So it instead constitutes an illegal lottery. So what we want to do through clauses 8 and 11 and Schedule 15A is to remove the normal costs of paying for a product or service from the definition of a lottery and make it easier, make it possible or easier to run those kind of competitions here. So to do that, under clauses 8 and 11 in the bill, we're inserting an extra paragraph into Article 131 and 168 of the 85 order, which basically says that arrangements aren't lotteries unless a person must pay to participate. And pay to participate is a common legal understanding of a lottery. In addition, we're then setting up this new Schedule 15A, which attempts to define in law what does and does not constitute payment to participate. This way we can prevent certain types of draws, but allow other types for the first time. So if we take the schedule, meaning of, starting at paragraph 2, meaning of payment, paragraphs 2 to 4, basically in that section, we want to make it clear what we mean by payment for the purposes of constituting a lottery. And that means paying money, transferring money's worth, or where the actual cost of entry to a draw is included or added onto the normal purchase cost of a product or service. And in paragraph 4 of that section, we want to basically make it clear that if a customer doesn't know that an entry cost has been included in the price of a product or whatever, it still counts as paying to participate and therefore is still a lottery. And then on the section headed stamps, telephone calls, etc., paragraph 5, the aim here is to make clear that the normal or ordinary costs of a phone call, postage, or other communication won't count in future as paying to participate under the bill, and therefore will be allowed for those kind of draws. Paragraphs 6 to 7, paying to know whether a prize has been won or payment to claim a prize. Our intention there is to make it clear that if a person has to pay cash or is charged in some way to find out the result of a competition or they've won a prize, it's a payment to participate and therefore is a lottery under clauses 8 and 11. And then paragraph 8, choice of free entry. Again, we're trying to prevent people from being automatically entered into commercial prize draws or competitions. In other words, under paragraph 8, we want people to have a means of indicating whether or not they want to be entered into a particular draw. So there's a distinction to be made between automatic qualification and automatic entry. And then finally, there's a power to make regulations, which is paragraph 9, which gives the department a new power to make regulations around any kind of new, novel, contentious, or highly unusual types of draws or competitions. It's basically a safety net or a catch-all for anything new that might come up in the future. So I've gone through, bearing in mind your time, that's gone through that as quick as I can.
That's great, Kieran. Look, thank you.
Right. I hope that's clear, or
15.
clearer.
15A members, anything you want to comment there?
Just very quickly, Kieran, thank you very much for running that through. The way you've articulated it is very clear. One question I have, see the stamps, telephone calls, etc. Is that whereby you might get a game show or you know, something on deck, and they do this phone in? Does that mean that Northern Ireland doesn't have to be excluded anymore? That type of thing?
Yes, normal cost is the key there, or ordinary cost. So that if it's ordinary cost, if there's some additional charge, that might still be a problem. But ordinary cost, phone calls or texts or whatever people have to do, would be allowed.
I don't know why I brought up on deck there, but I think there was maybe past history. I think there was past history in that.
Have you not been able to enter, Paul?
Maybe they got into.
As Paul's Saturday evening.
Or maybe they got into trouble in the past over these sorts of things. No, I'm clear, but I'm also very clear. It still doesn't tell me that a bank or a building society can offer. Yeah. So that's why I think the EFM is very important.
EFM? Yeah. Okay.
Thank you.
All right, then if we could turn then to the code of practice and then some of those issues that have been brought up by Drumbo and by NIACTA as well.
Okay, Chair, thank you. Important, just kind of a few general comments. Important to emphasise this is a draft code which we have issued for a focused consultation. It's not a formal public consultation. Minister hasn't made any final decision, and it's actually 6 weeks. 13th of January it was issued to the 25th of February, 6 weeks. Want to acknowledge that there's a lot of good practice amongst land-based operators, and the voluntary codes of NIACTA and the Turf Guardians were used in drawing up this code. And that Minister is keen to have a code of practice in place, and Minister recognises that some of the concepts which of particularly affordability checks need further development and may be better left to phase 2. And we see compliance with the code as a way to drive up standards, and that those premises who are not members of NIACTA and the Turf Guardians will be forced to operate more fairly. And on compliance, there's a phased approach. If we become aware that an operator is not complying, we will obviously write to them first, make them aware of the rules, and remind them that we can object, or indeed anyone, is the law as it currently states, anyone can object to the renewal of the licence, and then it would be up to the courts. I know that I think Paul said the phones went boogaloo. Well, I can tell you my phone's gone boogaloo as well. So we just want to hear what people think, and we will then take those comments, revise the code, and then we think that we will need a further extended consultation on that. And I just want to point out that this power in the bill requires a commencement order. So the codes, even if we had everything, all the processes completed, we would need a commencement order before we could introduce those codes. And then I'll just ask Kieran then, if that's okay, Chair, to go through the detail of the code with you.
Okay, go ahead.
Right. Okay. Conscious of time, I'll just say a little bit more about why the Minister wants a code and the basis of how this draft has been drawn up. And essentially, the Minister is keen to have an industry code of practice because one of the problems with the 1985 order, besides its age, is that it's inflexible in many areas, with even minor amendments requiring changes to primary legislation. Therefore, part of the purpose of having a code, through creating a code power through this bill, is to inject some more flexibility into the present system of gambling regulation and enable us to update and regulate practices more quickly and easily in the future. The second reason we're having a code is, and the Minister wants one, is to ensure we have a common understanding as to what actually constitutes good practice within the industry. Over the period of the review, we've heard a large amount of criticisms of the industry and lots of different ideas as to what it should and shouldn't be allowed to do. Now, not all of the suggestions for improvement are necessarily, in the Minister's view, appropriate for the face of the bill, and she feels they're better instead to be considered as part of the code. And whilst many of the criticisms that have been aired publicly about the industry may have merit, there are examples, in our view, of very good and conscientious industry practice, and we want, if we can, to capture these good practices within the code to help the public and licensing authorities more easily distinguish between clearly responsible operators and those who might be less responsible. Now, in terms of how the draft has been drawn up, obviously we're reflecting in a lot of areas the Minister's views. It's also an amalgam of other elements. Some of what you have is drawn from codes that we've received, as I say, from the industry itself, social responsibility codes and charters from the Turf Guardians Association and NIACTA. Others draw from the Gambling Commission codes of practice, and there are also elements within this code which take some account of what the Assembly's all-party group on gambling harm is recommending for land-based gambling in its report published in October. In addition, around affordability and the measures there, on self-exclusion schemes, we've looked at kind of consumer credit and the financial conduct standards. The code itself is divided into sections. So in some senses, it's codes as much as a code. So it may be we can bring in some sections earlier than others, but that's part of the reason that we do that, to cover broad areas across the industry. Its remit is within the framework of the land-based operations. And just one or two final technical points I'd like to make. On page 7 of your version, you'll probably see a reference to having due regard for Article 171 of the 85 order. That's coming out because the intention is in the bill is to repeal Article 171 under Clause 13. There are also references to certain articles in the 1985 order which may need to be renumbered in any final version because it's proposed to repeal certain preceding provisions as part of the bill, but we're leaving those to stand as they are for the moment, just to avoid confusion. That, again, as a quick run-through, is the code, if you like, overview of the code.
That's grand, like, thank
And
you.
and as I say, it's a draft, so we're waiting to hear responses back. We've heard some.
Grand, Kieran, look, thank you. And I mean, we all most definitely believe that in a code of practice, there needs to be a code of practice, and you can understand why there has been the reaction to this from the various interested parties. And we know that it's a draft code that we're working on. So I think we probably will have more discussion on this. We'll certainly have discussion with this after, or not after this meeting because we won't have time, but certainly first thing on Thursday morning as well. Can I just ask then, one of the points that NIACTA had brought up was the absence of a regulator. Who's going to enforce any code? What was the answer to that?
Well, basically, Chair, I think we touched on this last week, that we are using powers within the existing 1985 order. It says in the introduction to the code that on the scope section that it should also be prove useful. Go to my page. It should be available to. Bear with me. Yeah. The codes may be used by gambling licensing on page 5. The codes may also be used by gambling licensing, certifying, permitting and enforcing authorities as additional aid in assessing the fitness of any persons, companies or other bodies to hold a gambling license, certificate or permit. Under the present order, the courts, for example, need to determine the fitness of any person to hold a betting license. Similarly, the councils will with amusement permits and so on. So the codes can be used by licensing authorities, we would say, to help them assess someone's fitness to hold a gambling license or a betting license or whatever. We would also point out that the courts, anyone can apply to the courts to have a gambling license, a betting license refused or revoked or cancelled, and this is a mechanism too which the codes can be used on the basis of non-compliance with the codes. So even in the absence of a regulator, we believe there are ways that this code can be applied by licensing authorities.
Okay, Kieran, thank you. Members, Paul, you want to?
Yeah, that probably, whilst you need a code of conduct and everybody says it must be mandatory or must have teeth, you can understand why this would strike fear. You know the way you have this debate about may and must in legislation? I think I found another strong word, and that being but. Because if you look at the top page 8, it says in subsection 8, failure to comply with the provision of a code does not in itself make a person liable to criminal or civil proceedings. And then it goes, but. And you can see how that could be quite impactful, especially whenever it must be taken into account by the department, a court or a district council in the exercise of the function under the 85 order. So there is real menace with this, if you like. And with a code of conduct, we need to make sure that we strike a balance, because when you talk, Kieran, about reasonable establishments and less reasonable establishments, you also forget about that third sector, and that is the illegal bookmakers.
Yeah.
And what we can't do, or what we shouldn't be doing, is pushing punters or customers into a place where they're in the illegal bookmakers. And there's a certain irony in this, but sometimes, this might sound really daft, but sometimes when you have a problem gambler, the best place for them to be is in the one bookies, and the one bookies alone, where they can be managed and looked after to a certain degree.
Yeah.
So in knowing that, we need to make sure this balance is right. In subsection 10 on page 8, it says before issuing or revising a code under this article, the department must consult. Who makes the decision that the code needs revised?
Well, ultimately, the code is the department's code.
Yes.
So it would ultimately come down to the department and the minister to decide whether the code needs at any time to be revised or updated. I would imagine that as with the way this code is presented, some will depend on advice that we receive from, say, enforcement authorities, or concerns that are raised by public representatives, or even the issues that the industry may have, would all form into our consideration. And the idea is that if there is something wrong or something needs revised, it can be done with relative speed, but subject to stakeholder consultation.
Okay, I'm going to push on here. Obviously, we have massive issues around the affordability checks,
Yes.
the spend limit. I've crystallised my thinking on this, and this goes back to the debit card, credit card issue. And I don't, if there is a spending limit, how is that placed across bookmaking companies? And what you don't want to do is have a customer in spending a certain amount in one bookies and then going to another to spend exactly the same amount, and then you want that person to remain in the one place so he can be managed and looked after, or she can be looked after. So I have issues around that, and then also the self-exclusion piece, how that would actually work in practice, and whether if you self-exclude from a bingo hall, does that mean you self-exclude from a bookies also by extension? And the question, so those are the three areas where I have concern, as do most other people who have contacted us. I want to ask you a question, and I'll end. You talk about the 4-week or the 6-week consultation you're going through, but did I hear right that after that you will then go to a formal consultation?
Yes, that's right. We would intend then to after to consult on a final draft once minister, and it's likely to be an incoming minister, given that where we are in timings, that we would consult then formally on it. We're not obliged to consult publicly, but we are obliged to consult formally, so we would do that with the interested parties that's listed in the clause. So that's the industry and those representing interests of anybody impacted by.
Okay.
And they are all being consulted at the moment.
Yeah. Okay, how often do we do informal consultations which aren't public?
In this case, Paul, this is following the terms of the bill in clause 15 as to how the code of practice is introduced, and the requirements in clause 15 effectively require a stakeholder consultation. We are putting the code though on the web, so any member of the public, if they want to access it, can do so. Quite often within primary legislation, though, there are provisions for certain types of consultation which are not public consultation as such.
Should a mother of a gambling addict not be allowed to input into a consultation?
Of this kind, there's nothing in this proposal that prevents that happening. As I say, we are also consulting organisations that deal with gambling harm and addiction services, and so they are included in this consultation. And as I say, we're also putting this code out onto the web. So there is anyone who wishes to comment on it or wants to have access to this to review it should have that.
Okay, thank you very much.
Thanks, Paul. Could just bring in then quickly Ciara.
Just a quick one, and it's following on from Paul, in relation to, and I recognise obviously, and it's good that you are going out for focus consultation on this, with regards to, I'm just curious to be honest, regarding the whole area of affordability and customer care and affordability. Customer care is critical. Where did this original guidance come from? I know you've consulted a range of other codes of guidance and stuff, but specifically in relation to the affordability checks, where has that been before and who operated it, and any further information on that?
Yeah, first of all, I mean, the particular approach we're taking on the affordability is what we're trying to test out here is the idea of having some kind of trigger limit for an affordability check. I'm not aware where that's done anywhere else, and I know in England they seem to have ruled this out recently. But we have picked up on what the all-party group has suggested of for land-based of £100 trigger limit, and then we've tried to map out what that would look like to be in some way effective to try and contain gambling harm, for want of a better term. There isn't as such. The only place that I could really see this was in terms of financial conduct and credit worthiness type checks. These type of things that, as far as I see, are normally associated with lending rather than spending. So proposal is based around that. At this stage, what we want to do is, through the code and on the affordability, is to get a debate going around, is this people who want these kind of affordability tests, and the Minister certainly favours them, is this what people actually want to see who are advocating it? And then secondly, is it practical and effective? And if it's not, what other options might there be?
So I would assume, Kieran, the likes of this focus consultation, them key questions that you've just mentioned will be included within it. I think detailed conversation.
We want to hear now what people think, because we can't really come to a full conclusion on this until we've consulted, and the Minister's certainly keen that this is done in a reasonably open and transparent way, so that people, when we do reach a conclusion on it, there be some understanding of the basis on which that's been reached.
Thank you, and I think it's important with regards to that it can be operational.
Because I think if it's not operational, it will be meaningless, and a code of that kind will just lose any kind of respectability.
Okay, that's great. Thank you.
Okay, members, I'm quite conscious of time. We have 3 minutes left. I know we'll come back to discuss this on Thursday morning when committee meet up again. Can I just move you quickly on then to clause 16, which is the short title and commencement. Members, anything they want to ask further on that? Nope. All right, that's great. Thank you. Can I then just, Martina, ask you in relation to clause 9, will we then see the secondary legislation for clause 9 by next week, or at least a written briefing on what that will cover?
Yes, we certainly can give you a briefing. We haven't we have drafts, but they haven't been cleared by legal side yet. But I mean, I guess we can share them with you. That wouldn't be a problem for next week. Maybe not Tuesday's meeting, but certainly next Thursday's meeting, if that would be okay. But we will do our best for you, as we always do.
Okay, I know that, and I know, I mean, it's imperative that we get this information, and you know that every bit as much as what we do.
I know.
Again, quite conscious we have 2 minutes left, and Stephen Dunn has his hand up. Can we bring Stephen in to see what it is? Oh no, he's put his hand down. Sorry, he didn't want in. That's okay. Thank you very much, Martina and Kieran. That was great. Thanks for that today.
Thank you very much, Chair and members. Thank you. Bye-bye.
Bye-bye.
Bye.
Okay, members, I'm going to move on to agenda item 4, which is date, time and location of our next meeting. Can I advise you that the next meeting will take place on Thursday, the 20th of January 2022 at 9 a.m. in room 29. Thank you very much.
This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.